Hi, thanks for using my court coach. I'm Sarah, and I'm going to be discussing with you the steps you need to take in order to get your divorce or legal separation moving within the court system. Obviously, the first step is to make a decision as to whether you want to file for a legal separation or a divorce. Once you have made that decision, then the next step is to file the appropriate paperwork with the court and open up a case with them. So the way you do that, you're going to file a petition for either dissolution or legal separation. That's a Form FL-100. You're going to file a summons. That's a Form 110. And you're going to file, if you have minor children in the relationship, a declaration under Uniform Child Custody Jurisdiction and Enforcement Act, commonly referred to as a declaration under UCC-JEA. That is a Form FL-15. You will take these forms to the court with your filing fee, and the clerk will stamp them and open up a case for you and assign it to a judicial officer or department that will hear your case. She will give you copies of these forms back. These forms then get served on the opposing party. It needs to be personal service. Your process server will serve them with a blank response form, and that's an FL-120, and they will fill out a proof of service of summons. That's a Form FL-115 with the court that notifies the court how and when the respondent was served. The respondent then will have technically 30 days to file and serve a response if they want to participate in the case. One of the things that the court wants before they can accept either a settlement agreement or to set your case for trial is full transparency between the parties. So there is a requirement that if a party is participating in this case, that they need to fill out a set of financial disclosure forms that are commonly referred to as preliminary declaration of disclosure forms. These consist of 4 forms. There is the declaration of disclosure, that's the Form FL-140. There's the income and expense declaration, that's a Form FL-150. There is either, your choice, a schedule of assets and debts, Form FL-142, or a property declaration form, that's an FL-160. And the parties also need to serve on each other all tax returns that they have filed within the last 2 years prior to serving the disclosure documents. These disclosure documents are not served with the court, save for one form, and that is the FL-141, and that is the declaration regarding service of declaration of disclosure and income and expense declaration. That has to be filed with the court because that lets the courts know that you have complied with your disclosure requirements. If the opposing party is choosing to respond in the case, as I stated before, they will also have to serve the same set of documents on you. So I like to do these disclosure forms and serve them on the respondent at the same time that they're being served with the petition and the summons. It's just one less thing to have to worry about, and it gets the case moving along. But technically, the declaration of disclosure forms do not have to be served on the other side until 60 days after the petition has been served. So then once you have complied with these first few steps, what's the next steps to get the case moving? Either the respondent files a response, in which case, if you guys reach an agreement, you can submit a written agreement. If there is no agreement, the case can get set for a trial. If the respondent does not file a response, then you need to go by a default proceeding. You will wait 30 days to give them enough time to file a response. And if they do not, then you can choose to submit a proposed judgment along with the other needed forms for a default. A default is when the other party is being removed from the process and will not be participating in the process. And we will do a separate video that discusses how to pursue a default. If they do not file a response, but you guys are able to still reach an agreement, you can submit what's called a default judgment with a written agreement. And there's also a process for that that we will go over in a future video. The earliest you can be divorced is 6 months and 1 day from the date that either the respondent was served with your summons and petition, the date that he filed a response, or the date that the appearance, stipulations, and waiver was filed, and that's a final form that will be submitted with the judgment packet. But you cannot, and it's whichever occurs first of that. So legal separation, on the other hand, because there is no termination of marital status, has no waiting period. So I hope this gave you just a good overview of how to get a divorce or legal separation started and moving. And I hope you found this helpful. Good luck.